Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. In the present appeal, the insurance company has challenged the award only on the ground that the compensation awarded to the claimants is excessive and arbitrary, and the rate of interest awarded by the tribunal, that is 8% per annum, calculated from the date of filing the claim petition, is also arbitrary. It was argued by the counsel for the appellant that in column 6 of the claim petition, the claimant has stated the income of the deceased to be rupees 15,000 per annum, and therefore the tribunal had acted arbitrarily in determining the compensation on the basis of a notional income of rupees 20,000 per annum. It was also argued by the counsel for the appellant that the deceased was a bachelor, and therefore, while determining the multiplication, 50% should have been deducted as personal expenses from the notional income of the deceased, and the tribunal had erred in deducting only 1/3 as personal expenses of the deceased. It was argued that in view of the aforesaid, the award of the tribunal is liable to be modified by reducing the compensation payable to the claimant. Rebutting the argument of the counsel for the appellant, the counsel for the claimant has argued that the income of the deceased was stated to be rupees 15,000 per annum, column 6 of the claim petition, on the basis of the notional income provided in paragraph 6 of the second schedule. It was argued by the counsel for the claimant that under section 168 of the Act 1988, the tribunal is required to hold an inquiry into the claim and award just compensation, and the compensation payable to the claimants would not be reduced because a lesser amount was claimed as compensation in the claim petition. In support of his cross objection, the counsel for the claimant has argued that from the evidence on record, it was proved that at the time of his death, the deceased was earning rupees 5,000 per month, and therefore the tribunal had acted arbitrarily in determining compensation on the basis of a notional income of rupees 20,000 per annum. It was also argued by the counsel for the claimant that the multiplier has to be decided considering the age of the deceased and not the age of the parents of the deceased. It was further argued that the tribunal had also erred in not awarding any amount to the claimant for funeral expenses and loss of estate, as well as for loss of love and affection. It was further argued by the counsel for the claimant that the claimant was entitled to interest of 12% per annum, and the award of the tribunal awarding merely 8% per annum as interest of liable to be modified. Thus, it is held that the deceased was unemployed, and the argument of the counsel of the claimant that compensation should be determined taking the income of the deceased as rupees 5,000 per month is rejected. The notional income of the deceased and the consequential compensation payable to the claimant is decided later on in the judgment. When we understand the factual metrics in the backdrop of the objectives of the above two legislations, the controversy in the instant case assumes immense significance. There is an interest of the bank in recovering the non-performing assets on the one hand and protecting the right of the blameless tenant on the other. The Rent Control Act must be construed as such. A landlord cannot be permitted to do indirectly what he has been barred from doing under the Rent Control Act, more so when the two legislations, that is the SARFAESI Act and the Rent Control Act, operate in completely different fields. While SARFAESI Act is concerned with non-performing assets of the banks, the Rent Control Act governs the relationship between a tenant and the landlord and specifies the rights and liabilities of each as well as the rules of ejectment with respect to such tenants. These provisions of the SARFAESI Act cannot be used to override the provisions of the Rent Control Act. If the contentions of the learned counsel for the respondent banks are to be accepted, it would render the entire scheme of all rent control acts operating in the country as useless and nugatory. Tenants would be left wholly to the mercy of their landlords and in the fear that the landlord may use the tenanted premises as a security interest while taking a loan from a bank and subsequently default on it, and the landlord would simply have to give up the tenanted premises as a security interest to the creditor banks while he is still getting rent for the same. In case of default of the loan, the maximum brunt will be borne by the unsuspecting tenant who would be evicted from the possession of the tenanted property by the bank under the provisions of the SARFAESI Act. Under no circumstances can this be permitted, more so in view of the statutory protections to the tenants under the Rent Control Act and also in respect of contractual tenants along with the possession of their properties which shall be obtained with due process of law. The issue of determination of tenancy is also one which is well settled. While Section 106 of the Transfer of Property Act does provide for registration of leases which are created on a year-to-year basis, what needs to be remembered is the effect of non-registration or the creation of tenancy by way of an oral agreement. According to Section 106 of the Transfer of Property Act, a monthly tenancy shall be deemed to be a tenancy from month to month and must be registered if it is reduced into writing. The Transfer of Property Act, however, remains silent on the position of law in cases where the agreement is not reduced into writing. If the two parties are executing their rights and liabilities in the nature of a landlord tenant relationship, and if regular rent is being paid and accepted, then the mere factum of non registration of need will not make the lease itself nugatory.